Hello aspirants, welcome to Pragyān with IAS. In continuation with the issues that we're covering under the mains Manthanam, we have the second issue that arose in the recent news. Many editorials were seen in various newspapers. We have collated and tried to give a consolidated you know material on this. Let's get into it. So the topic is the Supreme Court and regional benches. It forms the part of GS2 under polity judiciary, right? So recently what happened was the Parliamentary Standing Committee on Law and Justice has recommended the Ministry of Law to establish the regional benches of the Supreme Court throughout India. Currently we have the Supreme Court of India in Delhi, right? So there is a need because India is a peninsular subcontinent, and given its huge geography, the other population resting in the southern peninsula do not get access to Supreme Court, limited by the geographical conditions. So therefore a recent Parliamentary Standing Committee on Law and Justice has recommended such a thing. So you need to sprinkle such stat, or you need to take quote relevant ministries and committees, like we have parliamentary committees on ad hoc issues, we have parliamentary committee which are standing, then we have financial parliamentary committees, right? So relevant committees you need to quote, then it gives a sense to the examiner that the person is well read. However, the apex court has dismissed the noting that the matter is sub judice in the present situation. So this was the event that came in the news, right? So that the matter is under consideration within judiciary, but it is not for public interpretation right now. So like that. Now we have certain let us discuss on each of pointers on arguments in favor of having Supreme Court and its regional benches. So let the Supreme Court have a main branch in Delhi and others in the other 4 parts of the nation, namely Bombay, Kolkata and Chennai, right? So what are some arguments in favor? Within Constitution of India, in the Article 130 we have mandating that the Supreme Court shall sit in Delhi and other places as the CJM may approve with approval from President. So such a provision already exists. It is not something new thing coming in, but such provision is already there in the Constitution. So relevant articles should be quoted under Article 130, like that. Then we have Law Commission report also suggesting the same thing, that there is a politico-historical reasons behind for the location of current Supreme Court's seat in Delhi, but it is also clogged with red tapeism and inefficiency, and therefore there is a need to expand its services in the other regions of the country. Such a thing is already given by Law Commission. And also the Bar Council, which is a statutory body of law regulating the law professionals and conduct. It also has submitted similar suggestion to the Chief Justice of India only, that let us have a Supreme Court bench setting up in different, especially in South India, because the geographical divide is greater here. At least these parts, Bombay and Kolkata regions can access, but the southern part seems very far off. Therefore such a recommendation already exists by the Bar Council. So you need to quote a certain committees, reports and articles which are very relevant. They can add a lot of weight to your answers. We also have NCR WC also, right? National Committee on Reviewing and Working Constitution, that you can quote like that. Then another topic in favor is that there will be an enhanced focus on constitutional matters. Currently Supreme Court not only caters to the constitutional interpretation etc., but also lot of appellate cases that they come and clog here for a long period of time. right? So that will hinder the focus of Supreme Court in giving importance to a greater the cases or issues that are of great importance, and the focus is shifted to many appellate cases. Therefore, there is a need to establish the regional benches. Now, the next pointer can be there will be an increased judicial efficiency and effectiveness establishing these regional benches, right? And when it comes to justice delivery system, local issues should be addressed locally. That is the whole point with which the justice delivery is rendered in its true sense, right? Then we have indigenization of judiciary with the historical things associated with judicial system of India. There has to be a strategic move away from English. There's a lot of English influence. Every single law, articles, constitution, everything is mostly focused with usage of English, with which when it comes to a petitioner or a person in need who requires a judicial service, many times won't even understand the verdict of the court, and therefore if regional benches are established, then people can have access to justice in regional languages, and even the courts, within the court, the judges, the lawyers, they can interrogate with the petitioner in a smooth manner, so that there is no communication gap, or really the justice is delivered in its true sense and the language barrier is removed, right? Then we have the reducing the pendency of cases. As you know, there's a stat here that at least 70,000 pending cases are there in Supreme Court, and presently we have a count of the Supreme Court judges up to 33 against 140 crore population. Can you imagine? And it is said that there was a study by one group called Daksha group. It studied that 86% of the cases took around 10 to 15 years to get disposed. So you can imagine the kind of pendency in terms of cases that come and clog in Supreme Court, right? And therefore this would increase, and there is a need to increase also the ratio of judges vis-a-vis the population, right? In fact, in all India judges case, it was mandated to have, or it was suggested to have, at least 50 judges per million population. So there is a need if you want to reduce the number of pendency of cases clogging in Supreme Court, there is a need to increase the judges, which necessarily means expanding its horizon and try to expand to the regional benches, right? That's how it goes. Then we have the national judicial services. If you remember, we have the central services under part 14, right, in the constitution. We have the Union Public Service Commission, the state public service commissions mandated. So there are recommendations to have national judicial services as well, and this should pave the way for attracting meritocratic students, just like the civil services we have, to strengthen the justice delivery system. So there seems to be that the time has come now to establish these services for greater outreach in terms of justice delivery. Then what are some arguments against establishing the regional benches of the Supreme Court? So the potential bias that and the influence that may prevail. So there are concerns that when we establish regional benches, then the political influence is can be seen, because judiciary is a highly centralized system, right? With in keeping in the judicial independence as a basic structure. Therefore, the biases of the regions may not go well with the say one region's value system may not be in line with some other regions value system. So there can be chances of regional biases and political influence that we may face. Therefore, this is one such argument against establishing the regional benches. And there is a chance of fragmentation of the jurisprudence. The whole system of justice delivery may get fragmented because of the divergent interpretations, right? So when it comes to interpretations of the legal principles, there can be inconsistencies happening, and therefore that can create further issues, right? The whole point is to increase the justice delivery, and if these issues come, then the whole purpose is not met. We have, right, dukkaushadam tadapi dukkham, which means a solution to a problem creates a bigger problem, so that shouldn't happen, right? Then we have burden on the exchequer. The treasury may face burden in terms of establishing new staff, resources, infrastructure which may follow, and maintenance of that would create a lot of burden on the exchequer in terms of allocation of funds, etc. The whole systemic and operational management comes into existence. Then we have the decentralization of judiciary. So as the current judiciary being very centralized, this may lead way for decentralization, but can create disintegration also in the institution. So there are worries in that direction also, right? And also increased litigation of cases, as I discussed. So what happens is, although we have the proposition is to have regional benches, but many of the cases get deterred just because the sometimes because of the bureaucracy or even judicial process takes time, that deters a lot of unwanted cases as well. So many unwanted or not so serious cases or frivolous cases would get deterred, but this will may incentivize increase in such cases which otherwise would have been avoided, right? This is one such argument against also. Then towards the end, what can be the way forward? Then we can quote some very valuable reports. Even the 10th Law Commission of India proposed that the Supreme Court can be split into two divisions. One is the constitutional division, another can be the legal division. The constitutional division can mostly focus on safeguarding the basic structure of constitution, safeguarding the fundamental rights, interpreting the constitution. All this, they are the real core job of the Supreme Court, to uphold the constitution and its integrity in India. And the legal division, which can cater to catering to hearing the cases, delivering judgments, all these other purposes which are of course important, can be a separate division. Then the focus is clearly kept in cognizance, right? Like that. Then we have the Malimet committee also. See, there are some names when it comes to polity or judiciary. We can quote some constitutional experts or some committees that are there, right? Even Law Commission comes, NCRWC comes. We have Subhas Kashyap, we have D.D. Basu, N.V. Ramana, CJI, like that. These experts we can quote. Then that will add a lot of weightage to your answers. The Malimet Committee on Criminal Justice, right? This was on criminal justice. Suggested that Supreme Court to have higher days of working, keeping in mind the pendency of cases. This was one suggestion. So, but higher working day would become difficult. Therefore, there is a need to establish benches. Former CJI N.V. Ramana proposed to have setting up the National Judicial Infrastructure Authority, right? Just like this, which will improve the judicial infrastructure, because regional benches and establishment would follow the infrastructure facilities. So all that has to be put under one body called the NJIAI. This was the proposition by the former CJI N.V. Ramana. Then broader judicial reforms that are to be undertaken, addressing systemic issues that are there. What are the basic issues? Judicial backlog is there of cases, delay in justice delivery system, and judicial vacancies, that the seats are not getting filled for the judges. So these are main issues that are there. So keeping in mind all these issues and the sufficient reforms in terms of judicial reforms have to be undertaken accordingly. Like this you can give. Sometimes you need to give the evaluator a good picture of or should entice the evaluator. Therefore you can make like a cloud and you can write way forward, right? And just take some arrows and say 10th Law Commission recommended such and such thing in a simplified manner. Then you have Malimet Committee said like that. Then you have former CJI NV Ramana said something like that. When you give pictorial presentation, then it catches the attention of the evaluator and makes him or her give higher marking, right? Yeah, so towards the conclusion you need to write a very optimistic and futuristic conclusion. Like, in envisaging the future of Indian judiciary, we must embrace the bold vision. What is that bold vision? Balancing of tradition with innovation, tradition with innovation, regional diversity with national unity. See, very catchy wording. And accessibility with excellence. See, all these words we may struggle as to get in the exam condition, but keeping in mind the real issues. What are some issues? There is a backlog and there is need of innovation. So innovation with tradition, and regional diversity with national unity, because when it comes to diversity of region on a regional basis, then unity is hampered. So keep that in mind. So balancing divergent views, right? And accessibility with excellence. You need to have accessibility with excellence. So like that, when you write, then these words convey a lot for the examiner. The establishment of regional benches for the Supreme Court could usher, then give a very positivistic answer also, that this can usher, be very hopeful, that crucial advancement in the justice delivery system, right? That is more inclusive. What is the outcome that we are expecting of having such an advancement? We want inclusion happening of various backgrounds of people. Then responsive, it is more responsive to the call of the citizens. Then effective for all citizens. So like that you can answer. Okay. Then what are some previous year questions related? So we can expect a question on this topic this year, because such a recommendation came by the parliamentary committee, right? But I think in turn there was the NJAC Act that came, and it was repealed in the I think 99th Constitutional Amendment, right, Act. So when that happened, I think this came in the news, and that year UPSC asked that question, right? And this was entailed in the third judges cases. So basically such kind of questions, when they come, you need to quote all the judges cases and give arguments in favor and against. I think most of the pointers that we discussed can also be included, meeting the demand of the questions segment wise, and you can answer. What are some keywords that you can keep in mind when it comes to polity and judicial independence, right? It's a principle of basic structure of India, basic structure of Constitution of India. Then justice delivery system, judicial jurisprudence. See, these are the political language that you need to use. You cannot just write the same language in all subjects. Every subject has its own language, and you need to use those keywords and statements, right? And principle of natural justice, spirit of the law, letter of the law, right? Very important. You can write this in many occasions. Judicial review, judicial reform, judicial overreach. We have judicial activism also under Article 142, like that, right? So like that, judicial accountability is also questioned. Judicial primacy of law, right? Law of primacy of judiciary, all that. So like this keywords if you can have, then it is easy to write answers. Yeah, so that's all for this session. You can find the PDF of this in the Telegram channel given in the link below under the video. Thank you.